Good afternoon and welcome to a presentation on Proposition 19. This is brought to you by the Office of the Santa Clara County Tax Assessor in partnership with the Trust and Estate section of the California Lawyers Association, also known as TexCom to some of you. My name is Ellen McKissick. I am the current chair of TexCom. TexCom, along with the CLA, is pleased that it can assist the Assessor's Office in disseminating this critical information to the members of the Trust and Estate section, as well as those attorneys who are not yet members and people who are not attorneys. We hope that you will choose to join the CLA and the Trust and Estate section in the future. The Assessor's Office has organized this panel of impressive speakers. The program is an hour and a half long. The program is being recorded and will be available for future viewing. The audience is on mute to the best of our knowledge, and if by chance it is not, we ask that all listeners hold their questions to the end of the webinar, especially because it is being recorded. We have left about half an hour for new questions. Copies of this webinar, the video copy with the audio, will be made available at the Santa Clara County's Assessor's Office website, and these webinar PowerPoints will also be made available there. The particular website is listed here. For members of CLA's Trust and Estate section, you are able to obtain a copy of this video recording on the homepage of the Trust and Estate section. We have some impressive speakers. I'd first like to introduce the Honorable Malia Cohen. She's a native of San Francisco, and before being elected to the Board of Equalization in 2018, Ms. Cohen served as president of the City and County of San Francisco Board of Supervisors. She's known nationally and she's recognized as a policymaker. Our next speaker on the panel is the Honorable Larry Stone, who has been the Santa Clara County Tax Assessor for the past 27 years. He is the past president of the California Assessors Association, known as CAA, and he was one of 5 assessors he was appointed to the CAA ad hoc committee responsible for uniform implementation of Proposition 19. Next, we have Nora Galvez. She joined the Santa Clara County Assessor's Office in 2000 and has 21 years of experience in evaluating change in ownership issues. She trains others both in the Assessor's Office and also for the California Assessors Administrative Services Association, of which she is a past president. Behind the scenes, in addition to our panelists, we have David Ginsburg, the Deputy Assessor, who will moderate the question and answer session. We also have Attorney Richard Moon, who may assist in responding to some of the questions. Some questions have been offered in advance in writing. The audience is asked to wait until the live session to ask its own questions. I'm sure everyone on our panel will do their best to answer as many questions as possible. I want to let everyone know that we have received hundreds and hundreds of written questions already, which they've tried to synthesize down into those that are similar. So we will try to get to your questions, but may not be able to. Before we begin our program, we must give a disclaimer. The information provided in this panel discussion is informational. It is not intended to be a legal interpretation of the law. It is anticipated that additional legislation, regulations, and statewide guidance will clarify the implementation of this constitutional amendment. If there's a conflict between the information provided in this seminar and the text of the proposition or other legal authorities implementing or interpreting the proposition, those other authorities will prevail. Finally, since we have a lot of material to cover, it is my job to move this program along so that we can get to all the questions. I apologize in advance if I interrupt any of our panelists to ask them to wrap up their portion of the presentation. We do have some time limits on them, and I'm only trying to move the program along. This is our agenda. It's pretty succinct. We will have the Honorable Malia Cohen to give introductory remarks. The Honorable Larry Stone will provide an overview. Nora Galvez will discuss Prop 19 implementation. Questions that were submitted in advance will be addressed, and we have left 30 minutes for new questions from the audience, which then we will unmute you so you can ask questions. I suppose some of them are being propounded in the chat room. With that, I will turn it over to the Honorable Malia Cohen, who will give some brief introductory remarks.
Thank you. Thank you very much. Can everyone hear me okay? Yes, thank you. All right. Well, good afternoon, ladies and gentlemen. Thank you for joining us this afternoon. You heard the moderator speaking about how impactful and this conversation is going to be, and I'm excited to be here. It's my pleasure to join Santa Clara County Assessor Larry Stone, as well as his excellent management team, for this virtual discussion about the impacts of Prop 19. And I also want to acknowledge and express my gratefulness to be joining the California Lawyers Association. So also want to highlight that Richard Moon is going to be joining us as well. He is a distinguished tax counsel from my agency, the Board of Equalization. He will help us navigate the ins and outs of Prop 19. And for your edification, we at the Board of Equalization are working in full partnership with all 58 county assessors to implement Prop 19 through legislation, through regulation, and most importantly, through guidance. So there are two really important key dates for us to make note of: February 16th and April 1st. The best way to approach the impacts of Prop 19 or to think of these two upcoming dates. First, on February 16th, significant property tax benefits will be taken away from parents and children and grandparents and qualified grandchildren. On April 1st, also a significant date, because new property tax benefits will be granted. They'll be granted to persons over the age of 55, as well as significantly disabled and victims of wildfires and natural disasters. Assessors throughout the state of California, including our very own Larry Stone here in Santa Clara County, have assumed the awesome task of educating the public about the impacts of Prop 19. My agency, the California State Board of Equalization, has a web portal with extensive information about how Prop 19 will work. It can be found at the top of the BOE website. That's boe.ca.gov, BOE as in Board of Equalization. The Board of Equalization will continue to issue guidance on Prop 19 on three major subject areas. First, more information on the BOE website, the BOE letters to assessors, and then, of course, new regulations that the Board of Equalization has adopted. There are several policy considerations to amend Prop 19. Before we turn this discussion over to our distinguished panel, let me express my concerns for Proposition 19. I believe that Prop 19 needs to be amended. This is because Prop 19 eliminated one of the best tools available to parents to build family generational wealth by passing on their home and their property to their children without the increase of property taxes. And you may be asking, like, why is this important? Well, for so many middle-class families and communities of color, the home is the real 401k. It is the vehicle that people use to save and spend down during their retirement and pass on to their children and grandchildren. And Prop 19 will force middle-class families to sell the single most important financial asset, and that's the family home. simply because they can't afford to pay the reassessed property taxes. This is why I began to dive more deeply into Prop 19 and believe that it should be amended so that we can restore the ability of families to transfer their principal residence and other property as currently provided under Prop 58 and Prop 193. So with these policy observations in mind, let us roll up our sleeves. Let's dive in and let's return to the discussion of the real world impacts of Prop 19. And again, I want to take a moment to express my personal thanks to Assessor Stone for his very important discussion, for the very important discussion we are going to have today. Thank you, and I turn it back to you.
And we will turn it over to the Honorable Larry Stone.
Well, thank you, Ellen. You know, I think I would like to start by thanking our partners, the California Lawyers Association and the State Board of Equalization member Malia Cohen, for joining us today. I especially want to thank Nora Galvez of my staff, who is one of the state's leading experts on transfers of ownership and currently oversees a team of assessment professionals in my office responsible for reviewing from 70,000 to 90,000 deeds we receive annually and to determine which ones are subject to reassessment. Well, assuming most people on this webinar do not have regular contact with an assessor's office, I want to provide some basic information about my office. Every 5 years, we are audited by the State Board of Equalization. In the 4 BOE audits during my 26-year tenure, the accuracy of our assessments have met BOE standards 98 to 99%. During my term in office, the assessment roll has increased 472%. That's from 115 billion in 1995 to 551 billion in 2020. My staff has increased only 4.5% during those 26 years. Santa Clara County employment, however, has increased 64% during the same time. We have returned 21.6 million of the assessor's budget back to the county general fund unspent. In other words, I have underspent my budget in 25 of the 26 years. The result, nearly $6 billion in property tax revenue each year for schools and local government. You know, the context is important for understanding Proposition 19. Assessed values have become valuable unto themselves. With the passage of Proposition 13 in 1978, assessed values are no longer market-driven. Instead, assessments are based upon the purchase price at the change of ownership or new construction, and then increase no more than 2% a year. As a result, assessed values over time become far less than the market values. One's low assessment has become a prized asset, cherished by longtime homeowners, but envied or even despised by younger, first-time homeowner wannabes. Over time, the voters have approved several ballot initiatives intended to retain low assessments, even passing assessed values onto their children, and in some cases, even their grandchildren. Proposition 19 is the latest in that effort, but it, like its predecessors, was terribly written. Attendance today has been reported on the webinar is overwhelmingly over 1,700 attendees. And while I'm pleased that my office is able to sponsor this event, candidly, I wish it wasn't necessary. For more than 2 decades, I have administered the property tax system based upon a simple premise that there were clear rules to the road. Proposition 19 contains major changes to the state constitution, overhauling or eliminating 5 previous initiatives. Many of the provisions are confusing, ambiguous, and conflict with the initial intent of the ballot measure. To make matters worse, there are no companion implementing legislation. To understand where we are today, it's important to know how we got here. For decades, with little success, there have been attempts to expand Proposition 60, the initiative passed in 1986, which enables homeowners over the age, the real old age of 55, to transfer their coveted assessed value to another home of equal or lesser value without reassessment to market value. Prop 60, principally designed for empty nesters wishing to downsize, is relatively straightforward. 2 years later, the voters passed Proposition 90, expanding this benefit to other counties. However, the inter-county transfer allowed each county to choose whether to participate. Not surprising, only 10 counties out of 58 agreed to accept Prop 90 transfers. The reason? The loss of property tax revenue, of course. Why did Santa Clara County opt in and accept Prop 90 transfers? Raw political pressure on the Board of Supervisors. In 2008, Florida voters passed Amendment 1, known as Save Our Homes, championed by Florida State House Speaker Marco Rubio, which allowed homeowners, just like Proposition 19, to retain low property taxes when they move to a new home. Like Proposition 19, the measure was initiated by realtors for the simple reason that it would create more transactions and therefore more real estate commissions. Encouraged by the success in Florida, California realtors began pushing for a universal Prop 90, allowing transfers to all 58 counties. The realtors' proposal, however, was a non-starter for parents and others concerned about the huge loss in revenue, estimated by the Legislative Analyst's Office to be $1 billion per year, negatively impacting funding for schools and local government. Undeterred, the California realtors mounted a massive campaign to collect signatures to qualify Proposition 5 for the November 2018 ballot. Proposition 5 also allowed homeowners over the age of 55 to purchase a larger, more expensive home in any of the 58 California counties and retain most of the property tax benefits, defeating the original intent to assist empty nesters, seniors who wanted to downsize from a large home, or to enable grandma to get closer to the grandkids. Proposition 5 failed by a margin of 60 to 40 because Californians are not Floridians. So let me give you my personal example. In 1975, I purchased my current home in Sunnyvale, a modest tract home, for $85,000. It's currently assessed at $276,000. But Zillow said yesterday that the market value of my home is $3.1 million. In the 43 years I've owned my home, I've paid a total of $78,000 in property taxes. And Proposition 13 has allowed me to save more than $500,000 simply by owning the same home for many years. Cutting funding for public education was a bigger concern than an additional tax cut for longtime property owners like me, already benefiting from Proposition 13. In addition, firefighters and teachers unions threatened to fund a campaign to defeat Proposition 5. Realtors argue that seniors living in high-valued homes with low assessments are trapped in their homes, and Proposition 19 frees them from this financial burden. Actually, first-time home buyers are the ones who are trapped out of home ownership. Firefighters and teachers unions told the realtors that unless they found revenue to offset the loss, they would once again fund a campaign to defeat a new proposition, just as they had successfully defeated Proposition 5. So California realtors had to find a major source of revenue to pay for the huge loss of revenue created by a universal Prop 90, available in all 58 counties. They decided on eliminating a tax loophole, the parent-to-child transfer. In 2017, California's independent legislative analyst issued a scathing report on the inheritance exclusion, Proposition 58, whereby children are able to inherit their parents' principal residence and retain their low assessed value. The LAO estimated that 60,000 to 80,000 property owners have received this benefit at a cost of as much as $1.5 billion in lost property tax revenue annually. In addition to the transfer of the principal residence, Proposition 58 also allows the transfer of additional property assessed at $1 million. The The LA Times did a serious investigation revealing the absurdity of this loophole. The Times reported that celebrities, Beau and Jeff Bridges, had inherited a 4-bedroom Malibu home from their actor father, Lloyd Bridges, with access to a semi-private beach and panoramic views of the Pacific Ocean. The investigation revealed that the Bridges rented the home for $16,000 a month and paid approximately $5,000 a year in property taxes. Candidly, California realtors did not really much care about this part of Proposition 19. They just needed to find $1 billion to offset the $1 billion lost from a universal Prop 90. Almost immediately, California assessors and other powerful interests, like the California Farm Bureau, identified major problems with the language of Proposition 19. Farmers who historically passed the family farm from generation to generation recognized that they would be big losers. Ironically, they may still be. With major political problems building and the likelihood of organized, well-funded opposition from farmers and labor unions, the realtors asked the legislature to step in and fix the problem. As a sweetener to moderate Democrats hesitant about supporting a tax increase, they promised that the revenue would be allocated with a special and very convoluted formula that would likely benefit rural counties over urban counties. In just 6 days, a half-baked Proposition 19 passed the legislature, mostly behind closed doors. It was so late in securing legislative approval that the governor had to step in and sign a special legislation tolling the required deadline in which an initiative must be approved by the legislature. Well, the result is the mess we are now dealing with, Proposition 19. It is why California assessors and the State Board of Equalization have been scrambling to try to interpret Proposition 19 and determine how we will implement it. More than anything, assessors want to make sure that we uniformly and fairly implement all tax laws. Equal application is not just a goal for assessors, it's a fundamental axiom. A property should receive the same treatment no matter where it is located. Subject matter experts in the assessors' offices of Los Angeles, San Bernardino, San Luis Obispo, and Santa Clara, together with the State Board of Equalization, have been meeting weekly to clarify and identify problems that must be addressed by the legislature. Some issues have been resolved by the BOE's legal counsel, Richard Moon, who is on this webinar today. Unfortunately, the legislature, limited by COVID-19, determined that they could not consider such a major piece of legislation and pass it by the February 15th deadline. Instead, they asked for what has been nicknamed a skinny bill, a bare bones bill that will be included with the governor's interim budget, which provides the absolute minimum issues assessors require to administer the parent-to-child provisions of Proposition 19. It's not ideal, but it will provide the desired legal authority for assessors and the BOE to act. Effective April 1st, 2021, Proposition 19 permits eligible homeowners, defined as those over the age of 55, severely disabled, or homes destroyed by wildfires or disasters, to transfer their primary home's assessment to a replacement residence of any value anywhere in the state. Under Proposition 19, pending clarity from the legislature and the Board of Equalization, eligible homeowners can keep their low property assessment when moving to another home anywhere in the state. Use special rules to move to a more expensive home. Their property tax bill would increase, but not near as much as it would for non-Proposition 19 transfers, and to use these special rules 3 times in their lifetime. Proposition 60 and 90 sunset on March 31st, 2021. To receive the benefits of these propositions, the homeowner must have sold and purchased the new home by March 31st. Please note that the Santa Clara County on March 31st is a holiday and the recorder's office is closed. To receive the expanded portability, homeowners must complete at least one of the transactions on or after April 1st. Property owners have 2 years from the transfer of the first property to complete the second transaction. Proposition 19 also supplements existing transfer provisions for victims of wildfires or disasters or owners who are severely disabled. Upon implementation, taxpayers will have to determine and apply for provisions which are the most advantageous for their particular circumstances. The rest of this presentation will focus on the parent-to-child transfers only. In March, we will have another similar webinar to focus on helping homeowners who wish to use the other benefits of Proposition 19. Starting on February 16th, 2021, Proposition 19 substantially narrows the property tax benefits for inherited properties. Specifically, the measure narrows the assessed value that can be transferred to 2 kinds of inherited property. Property used continuously by the child or the grandchild as the primary home, or property held as a family farm. The measure has a convoluted formula to qualify and compute the benefit. Basically, the assessed value of an inherited home or farm would increase if the price of the property that could be sold for exceeds the property's assessed value by more than $1 million, adjusted for inflation every 2 years. Nora Galvez will go into greater detail about the mechanics of the formula. To make things easier, our office has developed an electronic calculator that will enable residents to calculate their savings. The biggest change, of course, is the elimination of Proposition 58 and Proposition 193 from the state constitution, which currently provides generous property tax benefits to inheritors of homes and commercial properties. Properties transferred after February 15th will be subject to limited benefits. Our office will accept notarized documents, recorded or not, if executed before the Proposition 58 deadline expiration. Nora will explain what we know and how we plan to administer Proposition 19. Launching today, my office has created a robust website that includes legal opinions, new forms, and other information that will help you make informed decisions for your clients. In closing, I want to remind everyone that our intention is to provide a general summary of Proposition 19. It is not intended to be an absolute legal interpretation. Proposition 19 is a constitutional amendment, so additional legislation, regulations, and state guidance is necessary to clarify its implementation. If there is a conflict between the information provided here and the proposition or any legal authorities implementing or interpreting the proposition, the text of Proposition 19 will prevail. And finally, I want to remind everyone that we will do our best to provide general guidance. However, our office does not provide legal advice to specific situations. Now, I'd like to turn it over to Nora Galvez, the real expert on this subject.
Good afternoon, everyone. Can everybody hear me okay? Yes, okay, let me just make sure. Oh, there you go. Well, thank you so much, Mr. Stone, for that great introduction. I just happen to love these kind of transfer changes in ownership transfers. So I just enjoy them very much. But honestly, Proposition 19 is it's a little bit challenging for us, but I hope I can provide to you great information so that you can, you can follow along, and hopefully I can answer some of your questions. So just, housekeeping, I know it was already stated that this presentation is being recorded, and I will really appreciate it if you can wait until the end of the presentations to submit your questions by the Q&A by the Q&A function at the bottom of your screen. So that will be great. Perhaps as we go along into the presentation, some of your questions may be answered. Just one more time really quickly, I just want to reinstate again that, the information that I'm going to provide to you in this PowerPoint presentation is intended to provide only general information, and it's just a summary about Proposition 19. As you know, Proposition 19 is a constitutional amendment, and additional legislation, regulations, and statewide guidance are expected to clarify the implementation. We definitely encourage.
And this is Alan McKissick. Can you turn on your video so we can see you?
Sure.
Thank you.
Hold on a second. There you go. Can everybody see me now?
Yes, we can. Thank you.
Okay.
So much.
Oh gosh, no problem. Let me just go back to this page. And again, I just want to encourage everyone to, to consult an attorney to seek legal advice on specific situations. Everyone has a different situation. So we definitely, we are encouraging the taxpayers to seek any legal advice. As it was stated, today we are going to focus only on Proposition 50A, which is the parent-to-child transfers, and Proposition 193, which is transfers between grandparents to grandchildren. So let's begin with the parent-to-child exclusions. Proposition 50A is effective in November 6, 1986. It's a constitutional amendment approved by the voters of California, which excludes from reassessment transfers of real property between parents and their children. Proposition 50A is codified by Section 63.1 of the Revenue and Taxation Code. Proposition 58 includes transfers of principal residence.
We only see your first slide. We don't see you transferring through your slides. Sorry. You might want to tell everyone.
I apologize. I was just notified that you can only see my first slide. So let me see if I can fix that really quickly.
Ask them now.
Can you see the parent-to-child exclusion?
Yes, we can. Thank you.
Okay, perfect. I apologize about that. Okay. As I was saying, Proposition 58 is codified by Section 63.1 of the Revenue and Taxation Code. Proposition 58 includes transfers of principal residence between parents and children without any reassessment, regardless of the value. It also includes transfers that are part of the $1 million assessed value exclusion. There's no restriction on use of the property after the property has been purchased or gifted. The child can use the property as an income property, as well as the child can reside in this property. Again, the $1 million exclusion is for transfers where the assessed value of these properties where the properties are not the principal residence of the child. These properties are usually rental properties. And as long as the assessed value of these properties that the child will inherit does not exceed the $1 million, the child can actually have the exclusion, fully without any reassessment. It also includes commercial property. So the $1 million amount is the factor base year value, not the fair market value of the property or the properties. I just want to make sure that that is clear, because I know some taxpayers had asked about what value do we actually look at, and it is the assessed value, not the fair market value. In order for the child to receive this exclusion, a claim form must be completed and signed by the transferor and the transferee. The transferor is the person that is giving away the property. The transferee is the person that is receiving the property, and it must be filed with the assessors. A claim form is timely filed if it is filed within 3 years after the date of the purchase or the transfer, or prior to the transfer of the property to a third party, whichever is early. Now let's look at the grandparent to grandchild. And the grandparent to grandchild exclusion is somewhat similar to Proposition 50A. Proposition 193, grandparent to grandchild, is effective March 27, 1996. And also it is constitutional. It's a constitutional amendment just by Proposition 50A, approved by the Board of California, which excludes from reassessment transfers of real property from grandparents to grandchildren only, providing that all of the parents of the grandchildren who qualify as children of the grandparents are deceased as of the date of the transfer. Proposition 193 is also codified by Section 63.1 of the Revenue and Taxation Code. Proposition 193 includes also transfers of principal residence between grandparents to grandchild. And like I said, it can only be that transfer, grandparent to grandchild, without any reassessment regardless of the value, because we're talking about the principal residence. Also, there's no restriction on the use of the property after the transfer. The grandchild, again, they can decide to reside in the property, or they can decide to rent the property and use it as an income. All of the parents of the grandchildren, like I mentioned, must be deceased as long as of the date of the transfer. It can be as of the date of death of the grandparent, or it can be as of the day that the gift has been given to the grandchild. Something that I just want to mention really quickly is that there are certain provisions that exclude the parent to be deceased, and that is if there is a stepchild, a step parent relationship here. And if that is your situation, I highly recommend for you to look at Section 63.1 of the Revenue and Taxation Code for more information on the qualifications. I really love to show this graph to taxpayers every time I explain to them how Proposition 50A and 193 works. As you can see in this picture, you can see the red line, the market value goes up. However, if the child or the grandchild is keeping the assessed value, if they inherited or they purchased the home from the parents or the grandparents, they're keeping the assessed value. And with a restricted annual increase of assessed value to an inflation factor, not to exceed the 2% per year, just like Proposition 13 stated. So that's, like I said, this is something that I like to show to taxpayers when I'm talking to them about Proposition 50A and Proposition 193. So now the big question. Okay, so what is Proposition 19 and what are some of the changes to the current law because of this proposition? And that is the big question. So Proposition 19 was approved by California voters on November 3rd, 2020. And Proposition 19 adds Section 2.1, 2.2, and 2.3 to Article 13A of the California Constitution. It changes provisions on the parent to child and grandparent to grandchild exclusions effective February 16, 2021. But it also adds new provisions for base year transfers effective April 1st, 2021. And again, we're only, this afternoon, we're only talking about, our focus is on changes to the parent to child and the grandparent to grandchild provisions, and how that we are going to implement these changes. So what are the changes? under Proposition 19, effective pretty soon. February 16, 2021 is around the corner. So what are some of the changes? Well, what Proposition 19 is doing is limiting exclusions to only family farms or family homes. A family home has to be the principal residence of both the transferor and the transferee. And I think this is very important to make sure that it's understandable. The family home, in order for the taxpayer to qualify, it has to be the principal residence of both the transferor, but also the transferee's principal residence. Proposition 19 also adds a value test for family homes, which is coming from Section 2.1. As I remember, I just referenced that Section 2.1 was added to Article 13.8 of the California Constitution. So this value test is coming from Section 2.1, which requires an adjustment of a taxable value if the assessed value of the family home exceeds the sum of the taxable value plus $1 million. The taxable value means the base year value plus the inflationary factoring. And I'll give you an example of that in a minute. Okay. So before we get into in depth on the value test, let's look at the comparisons of the current and the future law. So as I mentioned, under Proposition 50A and Proposition 193, it allows transfers of principal residence between parents and children without any reassessment regardless of the value. However, Proposition 19, the new law is the value is limited to a current taxable value plus $1 million. Under Proposition 50A and 193, there are no restrictions on use of the property after the transfer. Like I mentioned, it can be the child or the grandchild can make this property their principal residence, or they can very well be an income property. Under the new law, the transferee must use property as a principal residence after the transfer. Under the current law, we have the $1 million in assessed value allowed on properties that are other than the principal residence without any reassessment. This is properties that are, rental homes. As long as the value altogether does not exceed the $1 million, we can very well exclude the child or the grandchild from reassessment, without any issues. However, under the new law, only the principal residence is eligible. Proposition 19 completely 100% eliminates exclusions for other than the real property. So that's really bad. If the parent or the grandparent has multiple homes and they want eventually for these homes to be inherited by the children or the grandchildren. So now let's look at the value test. So this value test has 4 steps. Okay, the first step is, first we're going to calculate the sum of the factor base year value plus $1 million. Okay, after that, step number 2, we are going to determine whether the assessed value exceeds the sum of the factor base year value plus the $1 million. Step number 3, we're going to calculate the difference. And number 4, we're going to add the difference to the factor base year value. And that's going to give us the new base year value that the grandchild is going to end up in the home. Okay, so I prepare for you an example. So let's look at this example. A single family residence has a factor base year value of $425,738. Parent dies on March 1st, 2021, and the property is inherited by the parent's only child. The property was the principal residence of both parents and the child. On the parent's date of death, the property has a fair market value of $1,750,000. Okay, so let's apply the first step here, okay? So we're gonna calculate the sum of the factor base year value plus a $1 million. So here you can see the factor base year value is $425,738 plus the $1 million, that equals to $1,425,738. Okay, so then after that, we're going to determine whether the assessed value exceeds the sum of the factor base year value plus the $1 million. So again, the fair market value of this property is $1,750,000, which is greater than the sum of the base year value plus the $1 million. Okay, so then step number 3 calls for the difference. We're going to calculate the difference, which is $324,262. So we're going to add now the difference to the factor base year value. So again, the original factor base year value was $425,738 plus the difference, $324,262, which gives us a total of $750,000. So these will be the new combined base year value for this child that inherited the home from the parent on March 1st, 2021. And again, this property is the principal residence of both the transferor and the transferee. Okay? So again, we're going to calculate the sum of the factor base year value plus $1 million. We're going to determine whether the assessed value exceeds the sum of the factor base year value plus $1 million. We're going to calculate the difference, and we're going to add the difference to the factor base year value. I know a lot of people were a little bit, concerned about this, and they had a little bit of trouble doing the calculations. So I hope this example kind of clarifies to you, and maybe perhaps it answers some of your questions. As Mr. Stone stated earlier, we have information on our website with the help of our amazing IS team. We have created a calculator that is going to be able to allow you to make these calculations. All you need is the fair market value and the factor base year value in order for you to be able to get the new combined base year value. So I hope this was helpful. Okay. So Proposition 19 has filing requirements. So the transferee, as I mentioned before, the transferee must make this home their principal residence. It has to be, the child has to live at this home. So the transferee must claim the homeowner's or disabled veterans exemption at the time of the purchase or transfer of the family home. If not filed at the time of the purchase or transfer, the transferee has only 1 year from the date of the purchase or transfer to file the claim for the homeowners or disabled veterans exemption in order for them to get the exclusion under Proposition 19. Okay. So one of the questions that I've been getting a lot lately, and a lot of my staff has been getting a lot from taxpayers or attorneys. So what should I consider, or what should my client consider if I want to take advantage of the existing law right now before February 16, 2021. So there's different considerations for everybody. Everybody's situation is different. But obviously, you know, there can a consideration has to be given to any financial or tax impacts that the person that is going to now be the property owner might have. Also, property rights. A lot of the questions that I've been having was, well, if my parent transfers the property to me, can my parents still reside in the property? Can I do a occupancy agreement? Can I charge rent to my parents? And so, you know, that's something that needs to be considered, you know, between the parties involved. Definitely, we want to make sure that these, you know, the taxpayers seek legal advice from somebody that really can answer these questions. We also want to make sure that after the taxpayer considers, you know, all of these, whether it's going to be something beneficial for them or not, we definitely want to make sure that they don't wait until the last minute. As Mr. Stone also stated, we are going to take the notary date as the transfer date. I know that, you know, the county recorders is a little bit behind on recording the transfers. So we will be using the notary date in order for, that will be the transfer date. But we highly recommend that these transfers are notarized, you know, prior to February 16, 2021. Another thing is that if I transfer my property to my children now, what other consequences do I need to be aware of? And as I mentioned, definitely the taxpayers need to be informed of any income tax, gift tax, or any estate tax consequences that this might cause by transferring the property to their children now, or the grandparent to grandchild transfer. We are advising them to seek legal advice. Again, we cannot provide any advice. We cannot, you know, answer these type of questions. So we're definitely pushing them to seek the help of somebody that knows this, you know, this law, so that they can better be informed. Something that I just want to mention again is that our website is a great resource. We have a lot of good information in our website. Also, there is a really good letter that the State Board of Equalization just published on December, let me look at the date, December 11, 2020. It's a letter to the assessor. Everybody can go, and it's a public information. Everybody can go and look at this letter. The number of this letter is 2020/061. And again, this is great information to have. It might answer some of your questions. This information is coming from the State Board of Equalization. So that concludes my presentation. And I am going to turn it over to this the presenter.
I believe that we are now going to turn this over to David Ginsburg, the Deputy Assessor, who's going to assist with the responses to the pre-submitted questions.
Okay, thank you, David.
Can everybody hear me now?
Yes.
Okay, and is my screen showing properly?
No.
No, okay, hang on one moment.
Yes.
It is now? Great, thank you. All right, let's do. All right, so I'm going to go through these questions, which were prepared in response to many, many questions we received. We tried to take and synthesize those questions. These are really advisory responses. They are subject to change. They were prepared for today. We hope that by the end of this, many of the questions that were submitted, you'll feel that we've sufficiently answered them as it relates to Santa Clara County. There have been many questions that have already been asked about, will what we're describing apply throughout the state? Afterwards, I may ask one of our members of the Board of Equalization or so there's a talk about that, but I can only, this entire presentation is focused on the 2 million people who live in Santa Clara County, and that's what this advice is for residents living in this county. All right, so first question, excuse me. Most questions today are about the parent-child portion of Prop 19, but I'm going to, there's one major question before we go into the parent-child part, which is all about the changes for the over 55 base year transfer. And the question is really, can an eligible property owner qualify for the base year value transfer if they purchase their replacement home now and sell the original home on or after April 1? And the answer is yeah. Basically, Prop 19 requires the transfer of the base year value to occur on or after April 1. It does not require that both the primary residence be sold and the replacement's primary residence be purchased on or after April 1. Therefore, in most cases, as long as either the primary residence is sold or the replacement primary residence is purchased on or after April 1, 2021, the base year value of the primary residence can be transferred to the replacement primary residence under Prop 19. However, as with all the questions, you know, again, we're doing our best, but there's potential for change. In terms of the, we've had also today a lot of questions about elements about a trust, what triggers reassessment. Tenants in common, joint tenancy, step transactions. I mean, just a whole large volume of those. In short, the rules governing what constitutes a change in ownership are unchanged by Prop 19. And they're not going to be addressed today. We're not in a position to answer the types of very specific trust questions people are asking. We do not provide legal advice. As noted by the BOE, the administration of a trust is governed by the trust instrument itself. For properties held in trust, the code section 61H provides that change in ownership occurs when any interest in real property vests in persons other than the trustor or the trustor's spouse or registered domestic partner when a revocable trust becomes irrevocable. And we've given you the rule, the property tax rule. We encourage you to take a look at that, 462.260. All of the rules should be available on the Board of Equalization website. Next question. Do we need to submit our application for the parent-child exclusion prior to the February 16th operative date to qualify for the exclusion under Prop 58, 193? This is really a big question everybody's been asking about. And again, I can only speak for Santa Clara County, but the answer is in short is no. As long as the date of the transfer or change in ownership of real property between parent to child and grandparent to grandchild occurs on or before February 15th, the transfer will qualify for the exclusion under Prop 58, 193. That's the existing law. The Santa Clara County Assessor's Office, in accordance with Property Tax Rule 462.200 and 462.260, will allow a different transfer date other than the recording date as long as the presumption is rebutted. For example, the use of a notarized document. This is our current practice in Santa Clara County on leases, contracts of sales, layups, etc., etc. Information on overcoming the deed presumption is contained in these two property tax rules. Additionally, we will accept a claim filed with the Santa Clara County Assessor's Office within 3 years of the date of transfer or before a transfer to a third party, or within 6 months of the date of notice of supplemental or escape assessment as stated on 63.1 of the Revenue and Taxation Code. When the Assessor's Office is notified, because people have asked us what happens if somebody passes away, when we're notified of the death, we typically will send out a request for more information. This helps us trigger the whole process so that you can get the proper exclusions. Please note, and I can't make this up, the Recorder's Office is closed for holidays on February 15th because there's a county holiday, and on March 31st, the days before each of the implementing dates. If a family home is gifted to 2 children, that's the next question. Do both children, and we've had a lot of questions on this, do both children have to reside in the family home as their primary residence to receive the parent-child exclusion? As one of 4 brothers, I can guarantee you that would not work in our household, and nor are we going to be requiring that. As noted on the BOE website, the exclusion is permitted if the parent's family home becomes the family home of at least one of the children, one of the qualifying children. Under Prop 19, if I inherit my parents' family home and move into it and establish it as my principal residence, must I live continually in the home to receive the parent-child exclusion? What happens if I move somewhere else? So the answer to this is yes. As Larry described, the goal was to try to get rid of the Bow Bridges example. And it is neutral on whether that you are the Bridges family or you are somebody like myself with just a townhouse. So one eligible transferee must continually live in the property as his or her family home for the property to maintain the exclusion. The home must become the principal residence of an eligible transferee or transferor within 1 year of the effective date of the transfer, and must file for a homeowner's exemption or disabled veterans exemption within 1 year of the effective date of the transfer. The same 1-year filing period applies to subsequent transfers to other siblings. If the property is no longer your family home, it will receive a new taxable value. The new taxable value will be the fair market value of the home on the date you inherited it, and adjusted each year for the inflation factor, which is published by the BOE annually. So if parent passes away, you have a year to occupy the house as one of the children. And if one of the children several years later wants to, they again transfer that to a sibling, then that other sibling must qualify in the same way, and they have a year. Okay, next question. Does Prop 19 apply to a transfer of a rental home? Same type of question. No, it doesn't. Prop 19 limits the parent-child exclusion to a transfer of a family home that is the principal residence of the transferor and becomes the principal residence of the transferee. A parent that has not met the residency qualifications in the year preceding the transfer is ineligible for Prop 19. Next question we got was, my client and her mother live in the same home and each own the home 50-50. They both qualify for the home ownership exclusion. If the home is appraised for $2 million at the time of mom's death, can my client use the $1 million limited exemption on her mom's half of the home so that it is not assessed? Yes, we are going to be allowing qualifying partial interest. Proposition 19 exclusion will be granted in those circumstances. Next question. There have been a lot of questions about farms, which is, we have farms in our county, but not nearly as prevalent as in other counties. In general, here is our current understanding, and I can't underscore enough, it's our current understanding. Prop 19 applies to the family home and the family farm. The definition for family farm is broad and described in the initiative. Portions of the farm not continuously used as a family farm are not eligible. A family farm does not need to be principal residence of either the transferor or the transferee, and thus both the family farm and the home are separately eligible for the exclusion. The family farm is determined by the appraisal unit, not by parcel. If there are multiple eligible transferees, only one must continue to farm to qualify the property for exclusion. So a farmer who has a home and separately a farm, even if they're contiguous to each other, they will effectively be able to apply twice for Prop 19. Next question. If a parent has already passed a primary residency onto a child under Prop 58, can they then pass their new primary residency onto a second child upon their passing under Prop 19? Yeah, yes, they can. Prop 19 is entirely separate from Prop 58. Properties transferred on or after February 16th can be eligible under Prop 19. So if you have benefited from Prop 58, or Prop 60 or Prop 90, that does not preclude you from being eligible under Prop 19 after the given dates. Next question. So there have been a lot of questions about whether assessors will consider delaying implementation of Prop 19. Other questions have been around just the unfairness or things they don't like about the initiative. The voters approved the changes to the state constitution. which has explicit implementation dates and direction. The assessor must administer the law and does not have discretion to set aside those portions for which they disagree. And so with that, I am going to now release my share. I'm going to start. I have some questions that I want to ask of our panelists to start off, and then we will begin to try to moderate some conversation here for the next 15 to 20 minutes. But I want to start off. Let's see here. I'm going to, Member Cohen, I'm going to put you on the spot here. There have been several questions here about the need for Proposition 19 being amended. What will be done to ensure that various county assessors will treat Prop 19 similarly? There's lots of questions about our approach to signing and recording documents, and will other counties adhere to that, et cetera, et cetera. And either you and or Richard might be able to chime in on this. If you could, please.
Sure. Well, good afternoon, everyone. My name is Malia Cohen again, and I represent you as well as 21 other counties on the State Board of Equalization. And the legislation that we're discussing, Prop 19, is a California Constitution amendment, meaning that this voter-approved initiative changes the Constitution. So there's no immediate, quick, and easy fix to remedy some of these challenges that we're discussing here today. We would have to literally go back to voters at the next opportune time to make a correction. Now, with that said, there are approximately 40 amendments that the Board of Equalization has submitted to a negotiation team within the governor's office and members of leadership within the California State Legislature to amend Prop 19 so that it is implementable. You see, the way things work is that the legislation passed, but there was no strategy passed on how to implement. So that is what we're actively doing now in Sacramento via Zoom calls, is to figure out a way to how do we implement this legislation. And unfortunately, during the time that the legislation was crafted, there was very little input into the piece that we are most concerned about here today on this call. So that is why it's a tricky piece of legislation to implement, and why we have an all hands on deck notifying the public of this major change. But we are actively working on it right now within the legislature. David, is there any other aspect of the conversation or of the question that I've missed?
No, I think that covers me. Larry, did you have a comment as well?
Yes. Proposition 13 in 1978 was 44 words. And it took nearly 3 years for the legislature to work its way through the implementation process of a 44-word ballot measure. In fact, Proposition 8 passed 6 months after Proposition 13, which clarified what would happen if a property lost value from its assessment. Nobody thought about it at the time in 1978, like a lot of people haven't thought about a lot of Prop 19, that properties could actually go down. So there is a possibility, as long as the voters, it's something that the voters understand, to eventually qualify another change, another ballot measure to change some of these problems with Proposition 19. But that's always problematic and very time consuming.
Okay, thank you. There was, and I may ask, let's see, Nora, there was questions about grandparent, grandchild exclusion. What happens when the father is unknown? So you can't prove whether alive or dead. And maybe you can just more generally talk about how we go about discovering and how do we deal with circumstances like that.
Yeah, yeah, that is actually very difficult because, like I said, in order for the grandparent, I'm sorry, for the grandchild to qualify for the grandparent to grandchild exclusion, both of the parents have to be deceased. However, if there is a surviving parent, the parent have to be remarried in order for the grandchild to qualify. before the transfer date, before the transfer to the grandchild by a gift or by a purchase or through inheritance. Yes, we had some situations where the child was raised by grandma and they don't know where mom is. What they have done is they have provided some documentation stating that this person is it's deemed to be missed or even dead because they don't know where this person is and it has been many years. So we had actually received some some notifications, and we have been able to actually exclude the property from reassessment. However, this is something it doesn't happen very often, so we really do look at each situation individually. So it really depends of what the situation is on that.
Thank you. There was a question asked, and I just want to make sure we clarify it, because if a parent passes, leaves it to the family estate in which there's 4 children, and one resides in it, and then subsequently that child moves out, another child moves in. The question was, is that a way effectively of getting around the sibling to sibling reassessment? I don't know if Richard or Nora want to address that.
I can address that. I don't think that's a way of getting around the sibling to sibling or the bar against sibling to sibling exclusions, because I guess what we would be presuming is that the parents left the property, for example, 25% to each child, with one child moving in, but the other 3, it's not that they're giving away their percentage interest to that child who's moving in. They're all keeping their 25%. When the first child moves out, the second child could move in, but again, they're all still keeping their 25%. There's no transfer of the interests going on. So,
thank you. There was a question about whether we will be doing another webinar focused on the other part of Prop 19, which is what we call the base year transfer for people who are qualifying, people who are over 55. The answer is yes. We have it scheduled in March, and we will have information on our website as soon as possible. So that is coming up, and you should be, we'll go through a similar presentation focusing exclusively on that portion of it. There have been a question, and I don't know, Larry, if you want to answer this, or I can, about how does the assessor arrive at the factor base year value?
Yeah, I caution my staff, but apparently they don't listen. Just eliminate factored, because nobody understands it. It's a base year value. The factoring is just increasing the 2%, no more than 2% every year. The base year value is established, I think, as I mentioned in my remarks, only twice, or in 2 instances. A change of ownership, you establish a new base year value, which generally is the purchase price, or new construction, the base year value is established at that time. And it never changes except for the annual factoring, the 2% each year, until there is either additional construction, like if you did you remodeled your house and you added square footage or something like that, it stays at that. And that's why I paid $85,000 for a house that's worth $3.1 million, according to Zoom at least, and it's only assessed at $276,000.
Thank you. And so again, we're going to be looking to the market value ultimately. It's okay. So with that, we have some questions. There were some people who've raised their hands, so I'm gonna look to that list right now, if I can. And we may ask a few people who want to ask a question can do that. I'm just trying to get my participants. Okay, so I'm going to unmute people. I will cut you off if you're not asking a question. This is a time for people. There's a lot of people on here and they want to ask questions. And so I'm going to just start at the top of this list. And I'm going to start with David Yu. You are live. You want to ask a question? All right, we're going to go to Bob Mackey. I'm going to ask you to unmute, and then you'll be followed by John Willoughby. If you are, all right, we're going to follow it by Jerry Wong. And now David Andrews. If any of you are
David Andrews here.
Thank you. We can
You may have answered this on the first question, but I have a client that bought before they were 55, a resident last month. They're going to be 55 in August. They want to sell after they're 55. Can they use the over 55 exclusion?
Richard, do you want to answer that? Or Nora, either way. Richard, how about you? You want to jump in there?
Sure. Yeah, based on what we know now, that they would qualify as long as one side of the transaction or the other, either the sale of the original property or the original primary residence, or the purchase of the replacement primary residence is done after April 1st, 2021.
And they meet the age qualification.
Of course, yes.
Yeah, okay.
They meet the age qualification when they sell in August and they're 55, but not when they bought in December.
Yeah, so the current requirements are that at the date of transfer, the person is over the age of 55. And then section 69.5, again, which is the current statute that governs those transfers, says you're over the age of 55 if you are at least 55. So as long as they're at least 55 on the date of transfer, I think they would likely still qualify.
Thank you very much.
Thank you. We're going to move to Bob Mackey, and then we'll be followed by Brian Shelter. Mr. Mackey?
Yes, this is Brian Shetler.
Great, terrific. Mr. Shelter, go ahead.
Yeah, I have a couple of questions. First is, you know, under many situations, there's a transfer of an interest in a piece of property, and then a contribution to an LLC by a child and a parent. Up until February 16, that kind of back-to-back transfer was protected from the step transaction doctrine. Now with that first transfer not being a parent-child exclusion transfer, is the position of the Santa Clara County going to be that we will take a look at that as a step transaction and not a proportionate transfer immediately following?
Nora, correct me if I'm wrong, but as far as I know, Prop 19 does not change how we handle a trust or transactions like this. It's silent on that.
That is correct. That is correct.
So I think it's no longer a parent-child exclusion transfer. And the law right now is that a parent-child exclusion followed by a contribution to an LLC cannot be collapsed as a step transaction.
Yeah, David, maybe I can jump in here.
Thank you.
So in the kind of transaction that you're talking about, that was quote unquote blessed by some uncodified language at section 63.1.
Correct.
And what it looks like now is that 63.1 is not going to apply because that carried off of the legislative intent. And that legislative intent is not the same legislative intent as Prop 19. And so it's very possible, very likely that that uncodified note, what that allows you to do is not going to be quote unquote blessed under Prop 19, as well as those transactions, those specific steps that were blessed in that uncodified note were typically used to pass the $1 million of other property, and that's not even available anymore under Prop 19. So
right. Okay, so that might be collapsed as a step transaction, resulting in a non-proportionate transfer into the LLC.
It's possible.
Okay.
Possible is the key word because we just don't know how the law right now, it's in flux.
My second question is does anybody have any, on this panel, have any insight to discussions about or any possible challenges in court about whether this proposition amending the Constitution exceeded the single subject rule and might be unenforceable.
Do any of the panelists want to take that on? Because we're really not set up to do that, but if anybody
Yeah,
wants.
I mean, I can just say I've heard a number of different arguments as to the unconstitutionality of Prop 19, but I'm not aware of any court challenges or any group having done anything other than sort of bring up some potential problems. So I'm not aware that anybody's sort of done anything officially to begin a challenge process.
Okay, I'm going to move on to, thank you very much for your questions. I'm going to move on to Anju, and followed by Mazen Salafiti. I apologize, I butchered your name.
Okay, thank you so much. My question is, I own a property with my siblings, and that was a long time ago. So we're thinking about changing from tenant in common to joint tenant. Would that trigger any reassessment? Because we bought this property back in 1990, I think.
No, that will not trigger a reassessment under joint tenancy property tax rule 462.040. So what the property tax rule says that if you transfer the property from tenants in common to joint tenancy, all of the grant transferees become original transferors. So I would really highly recommend for you to go and look at that property tax rule so that you can see how everything works.
So I can do it after February, I guess February 16.
So Proposition 19 is not affecting joint tenancy transfers at all. Only the parent to child and the grandparent to grandchild.
Okay, because we are thinking about changing to joint tenant so that one of the survivor, if we have no kids, will be the one holding the property.
Right.
So it will not reassess. Thank you so much.
Okay.
Okay, Mazen?
Yes.
Oh.
Can you hear me?
Yes, we can. Please go ahead. And you'll be followed by Paula Goodwin.
Great. Thank you. Thank you all. Mr. Stone, I think you mentioned the fact that if a deed is notarized but not recorded prior to 2/16 of 2021, but it's recorded after, that Santa Clara is going to declare that still a transfer prior to Prop 15's effective date. Is that the?
Yes, as long as it's notarized prior to the expiration date of the proposition, we will accept it because we know that, that the recorder's offices are behind. Everybody's affected by COVID-19.
Right.
And so to expect, by the time they got a document, if they got it the day before, it probably would not be recorded for maybe a longer period, maybe a week or two or a month. So we will accept a notarized document.
Okay.
And that is based upon the property tax rule. It's not necessarily just a declaration from our office. That's based upon 2 different property tax rules, and those were in the questions I went over. And we'll be posting those. The entire presentation, all the Q&A, will be posted to our website shortly after this presentation.
Okay, and just a clarification. That's county-wide, then, is what you're saying?
That's in Santa Clara. That's yes, in Santa Clara County. Exactly. Paula Goodwin, thank you very much.
Yeah. Can you hear me?
Yes. And Paula, you're going to be followed by Marion.
Okay. Well, I appreciate that Santa Clara has that view because Alameda County, we were told, I'm doing lots of these deeds, does not have that view. They're saying it is the recording date that applies, at least last I heard, unless that's changed. I mean, is the BOE, and I guess my question is to the director to the BOE, that just is maddening that there's inconsistency between counties in that regard. And particularly if you've got people filing in different parts of the state. What is the thought about reconciling all of that? There's just a real unfairness to that. So I just wanted to express that.
Yeah, Paula, this is Malia Cohen from the State Board of Equalization. I agree with you. It is maddening and it is something that we're looking to do urgently. Our role as the Board of Equalization is to make sure that the practice at the rulemaking is universal. And so unfortunately at this time, counties do have their own discretion, but we are working to implement some rules to make it universal.
Great, thank you so much.
You're very
Okay,
welcome.
Cal-
So
If I could-
I was going to say, Paula, just stay tuned and follow the BOE's websites for updates that we're putting up and posting on a daily basis.
Thank you.
You're
The California Assessors Association is very sensitive to things like this. This is not the only time it happens. And generally, the California Assessors Association consists of all 58 assessors. And we work very hard among ourselves to make sure that as much as possible, we have a consistent application of all the property tax laws. Some things are different from one county to the other, but when it comes to the Revenue and Taxation Code, it should be implemented uniformly.
Agreed. Thank you.
David, if I could.
Yes, go ahead, Richard.
Real quickly, there actually already is a rule on the date of change in ownership. And what that rule says is that if the transfer is evidenced by a recorded deed, then the date of the recording is rebuttably presumed to be the date. So already, it's just a presumption that can be overcome. And Santa Clara has decided that a notarized document will overcome that presumption.
Yeah,
Great.
and it may very well be that Alameda, the information is changing quickly. They're like us, they are all scrambling to try to figure out how best to implement this. The Assessors Association, is, like Larry said, is working around the clock together. So it may be just that they haven't yet been able to communicate their policies.
If I can, David,
Yeah.
just to follow back up with Paula, I'll put a call into Fong Law when we get off this call and talk to him a little bit about his interpretation of this dilemma, this issue. Okay.
Thank you so much.
You're welcome.
Thank you.
The next question is Marion Lenz, and then followed by Jeffrey Jordan. All right, I'm gonna, and look, I just realized in terms of the time, we're at 3 o'clock, and I know we promised to be done by 3 o'clock. Are the panelists willing to stay on for another 10 minutes to try to answer some more of the questions? Does that work for everybody? Because there's a lot of hands up, and we've had some pretty good questions here.
Yeah, I am.
Okay.
I've got a 3:30 hard stop, but I can stay on.
Everybody else okay with that?
I'm okay with
I'm
that.
good to go.
Great, terrific. Okay, so our next individual, Marion Lenz, if you are there. Otherwise, we'll move on to Jeff Jordan, followed by David Graff.
Hi, Jeff Jordan here. Thank you for doing this. 2 quick questions. David, you said that an eligible transferee has to remain in the family home for life. What if that eligible transferee is 55 or older and wants to take this inherited value and find a new home and transfer yet to another home? Is that possible? That's the first question.
Nora or Richard, you want to answer that?
I can take that one. Yeah, I think that would likely be possible. The only, or I should say at least one restriction that jumps to mind is that when they sell what was their family home, that family home must be reassessed. So they could take the base year value and transfer it to a new residence, subject to all of the new rules, but their old residence would have to be reassessed.
And when they transfer to the new home, are they stuck in that new home for life in the same way? That's still my first question.
Yeah, I don't believe that. I don't believe they would be.
Okay, and my second question, very briefly, is the sibling issue. If siblings inherit a family home and then transfer their tenancies in common into a joint tenancy and become original transferors, can they then keep that inherited assessed value going as each one dies? And is the answer different if they inherited their tenancy in commons in unequal proportions?
Well, I guess I'm not sure if I followed you completely, but I guess what I'll say is that the joint tenancy rules and the Prop 19 rules work independently. So if it's going to be a change in ownership or not a change in ownership under the joint tenancy rules, I don't think Prop 19 is going to change anything about the about the joint tenancy rules. And then in terms of if there are unequal tenants in common and then they become joint tenants, I think there, I think there has to be some kind of transfer, because I think one of the requirements for joint tenants is they hold it equally.
Okay. Thank you for your
very
question. I would like to ask Mr. Graff, are you available? And you'll be followed by Mary Lynn.
Yes, thank you. My question has to do with the slide, something that you put on the slide earlier with regards to family farms. You indicate that a family farm is determined by appraisal unit, not parcel. And so my question is, I'm unfamiliar a little bit with appraisal unit terminology, but my example is you've got a family farm that is multiple APNs. And I'm curious how the $1 million limitation or the $1 million exclusion is applied to all of those parcels. Is it collectively and then ratably, or do you get $1 million per parcel?
It is not per, it is our interpretation at this juncture, and that's subject to potential change in legislation and things like that. But it is our interpretation that the purpose was that what we refer to as the appraisal unit, i.e. what would transfer in the open market. So if you have, 500 acres and 100 acres is distinctly one type of farm, and the other 400 another type of farm, then there's potentially two farms. It's how would the property transfer in the open market is how the general concept of the appraisal unit, and that's how we will be. That's how our office at this point will be approaching it. And we look to the language in the law and the intent to arrive at that determination. Did that answer your question?
I think so.
Okay, thank you very much. The next person is Mary Lynn, and Mary, you will be followed by Val Velasquez.
Hi there, thank you so much. Can you hear me?
Yes, we can. Thank you.
Okay, great. I just wanted to ask very quickly, if a child is placed on title as a tenant in common under Prop 58, so as a gift, then later on, I don't know how long you want to wait, it gets converted to joint tenancy. Does that always qualify the child as an original transferor if you overcome the step transaction doctrine?
Under the property tax rule, joint tenancy property tax rule 462.040, transfer from tenants in common to joint tenancy are excluded from reassessment. The transferees become original transferors.
Okay, so, and then very quick second question, if I could. This is on the 55 and over. Clients live in a houseboat. They don't live, and they rent out their Los Altos home. They're thinking of selling the Los Altos home under Prop 19. Do they have to move back and establish residency in their Los Altos home first? And if so, how long do they need to live there before they can sell and get that claim for the exclusion under Prop 19?
Richard, Richard or Nora, you want to take that?
Yeah, I think if it's not, well, what qualifies to be transferred is the base year value of the principal residence. So it would have to be their principal residence. And if it's not, they would have to move back in and make it their principal residence. There's no time limit or requirement that you have to follow. So there's nothing that says they have to live there 6 months, 1 year, 6 years. What's required is that they're eligible for the homeowner's exemption. And so, that's what they need to do.
Okay.
And the homeowner exemption does make clear it has to be their principal place of residency, and there's time rules in that as well. So we're using as a general barometer 1 year,
okay.
As a general approach. But we'll be looking to what is the law and what are the rules and how's the homeowner's exemption been applied, et cetera, et cetera. The next question is Val Velasquez, and Ms. Velasquez, you'll be followed by Cassandra Francois.
Thank you. Thank you for this presentation. That's actually a good segue because I'm wanting to know, so before we notify the assessor and file a BOE 58 form to notify there was a claim for exclusion, now if we're doing a transfer and the transferee, adult child transferee is going to live in the property, are we just filing a homeowner's exemption on the BOE 266 form? or is there going to be a new form that we're going to use?
There will be a new form.
Yeah.
Okay.
The forms, my understanding is that they've been working, this is an example, assessors and the Board of Equalization, led by the BOE, really has been really working hard to put together a whole slew of new forms to deal with this. I know they're working on them as we speak.
Yeah, that is correct. Yes.
Okay, so just keep a watch for that. And the second fast question is, and I think you've answered it already, how does the adult transferee have to live in the parent's property that was transferred to them for life? Is that what you're saying? Or is there not a determination about that yet?
So it's our go ahead, Richard.
Okay, yeah, so so right now the way things stand is the eligible transferee qualifies for the exclusion as long as that real property is their principal residence. So as long as when it's not their principal residence anymore, the exclusion will no longer apply.
Wow. Okay, thank you. Thank you very much.
Thank you. Next person is, let's see, I just lost it. I think it's Joan LeBlanc.
Excuse me, this is Cassandra Francois.
Oh, Cassandra, I'm very sorry. Thank you. Thank you.
Not a problem.
Thank you.
so
Please go ahead,
much.
Cassandra.
Okay, thank you for the presentation.
And then Joan.
My question is, if you can talk, if anyone on the panel can discuss, if there's a parent that wants to make a transfer of their principal residence or any kind of real property at this point prior to the time that Prop 19 goes into effect, and they are thinking of either placing that interest in the real property in a trust or in a business that would then later transfer to children after Prop 19 has taken an effect, to what extent might that preserve that transfer under our current law, or and specifically if it's going into a business entity, would that only work if the parent has less than a 50% interest in the business entity, and could they still then be maybe like a primary manager or exclusive management of the
I'm not sure I caught the tail end of that, but what I will say is, in terms of rules of that pertaining to transfers into trusts or transfers into some type of a legal entity, if the transfer is done, so if there's a change in ownership prior to the Prop 19 effective date, the old rules will apply. And then if a transfer occurs after February 16th, then the new rules are going to apply at that point. So for example, if you transfer a piece of property into a legal entity, well, then Prop 19 Prop 19 doesn't affect that, and it's just going to be the legal entity rules that apply. And so whatever happens now is going to depend on what the legal entity rules say about that. And then when the legal entity interests are transferred after February 16th, again, it's going to be the legal entity rules that are going to dictate whether there's an actual change in ownership of a reassessment of the real property or not. And then the trust rules are going to be governed by, I think Nora had mentioned the rule 462.160.
Sandra, does that answer your question?
Yes, it
Great.
does. Thank
Okay.
you.
Moving on to Joan LeBlanc, and you will be followed by Barbara Sonnen. All right, Barbara, if you're there, you want to go?
My questions are about farms, and as you said, you don't have that much in the way of farms in Santa Clara County. But one question is can you only transfer one farm? So in other words, is the base year value plus the $1 million, that whole calculation, is that applied per farm or per appraisal unit, as you call it? Or can you have multiple farms? Because I mean, I've read the proposition 16 times and it doesn't seem to say. So I'm trying to find out what the interpretation is so far on that.
My advice would be to wait, because the law, I suspect this is going to be addressed through either the rulemaking process or through the state legislator. And I realize that's not a very satisfying answer, but we also are trying to better understand this as well.
Okay, so if I can ask a corollary question, and you know, it's probably the same answer, but I can try. So if land is in Williamson Act and it's being, you know, transferred to the kids to continue in Williamson Act and continue as an active farm, when the valuation is done to see if whether there's a need to bump up that value based on that, you know, value plus the million, is that based on Williamson Act value, on the value if it was divided up into subdivision lots?
Richard, do you know the answer? Because I do not.
Yeah, so I think the way that the Williamson Act works, it's a lower of. And so whatever, I guess, if there is an increase to the base year value after Prop 19, if the Williamson Act is lower than that, I think the Williamson Act value would still apply.
Thank you.
Okay, and then Joan LeBlanc, I don't know if you've come back on, and you'll be followed by Joanne DeHera, apologize your name. Joanne, if you're there, go ahead, because I think Joan is not participating here.
Yes, thank you.
And followed by Angel.
Yeah, this is Joanne DeHera.
Thank you.
Thank you for unmuting.
Yeah.
My question was, I originally purchased a home that I was able to have it under the original Prop 58. And just recently, my mother passed away, in which I will be inheriting 50% of the value of the current home prior to being reappraised, I guess, or at reappraisal. But my question is, do I have the opportunity to keep the first home still under the tax exclusion or reduction, or only one home? If I make my mother's home my primary residence.
Nora or Richard, do you want to take that?
I apologize. Can you repeat your question? I'm not sure if I follow.
Okay, so the original home that I purchased back in 1975 was purchased under the Prop 58 exclusion, and it has been my primary residence. My mother just passed away last month, and my sister and I are on in her trust to inherit. So I would be inheriting 50% of the home, of my mother's home. So if I were to move into my mother's home to make it my primary residence, does that then eliminate my previous home that I purchased back in 1975? Do I lose that ability to be under either 58 or now transferring that over to Prop 19? I'm not sure how that's going to work. If I lose one and keep the other, or do you keep both houses under the exclusion or the lower property tax?
So the first home was your home. Right. It was under Prop 58. So you received your home from your parents, and you guys applied for Proposition 58, and it was fully excluded.
No, I purchased my first home.
You purchased
I didn't receive it from anybody.
Okay.
My first home.
So if I think I understand this correctly, you have a home you've owned for many years. You may rent that out, and then you want to move into your mother's home, and she has passed, and she's under, and she has passed prior to February 15th, so it's under Prop 58.
Yes.
So in that situation, then the rules apply to Prop 58. I think.
Yes, there's no issue. Change. Yes.
There's no issue.
Correct.
Yeah.
So both homes can stay under 58?
Well, one is under what's called is Prop 13, like every homeowner, and that's, there's no rules on what an individual does. I live in a home, I can rent it out. There's no prohibitions on that.
Right.
The other is
which is her home, which is your home. Yes.
And you can do anything you want with that. It's only in the issue of having to do with Prop 58, or rather Prop 19, where you get into issues of residency.
So I don't have to stay a resident in my first home.
No, you will no longer be able to claim the homeowner's exemption, which is a $7,000 assessed value reduction, which translates into $70.
Okay.
If I'm going to move on, if that's all right.
Thank you.
Thank you. Okay, so I think the next person I have is Angel, and we'll have one or two more, and then we're going to have to close it down.
Thank you. This is Angel Hess. On the parent to grandchild exemption under the new and improved Proposition 13, what is the situation when mommy and daddy were not married and the grandchild exists? Does the mother and father still both need to be deceased? Because I have a lot of clients that have children out of wedlock, and I'm wondering if a grandchild can inherit from one of his parents' parents if one of his parents are deceased, but his parents, the two of them, were never married.
Yes, the answer is yes. So the father or the surviving parent is not considered to be the child or the grandparent because they were never married. So in this situation, yes, it will qualify for the grandparent to grandchild.
Even if the other parent is not dead at the time that the grandparent passes away or transfers.
Correct, because the surviving parent is not considered to be the child of the grandparent because they never marry.
Okay, that makes sense. Thank you very much.
Sure.
Okay, I'm going to move on to Brooke, and this will, and we'll have Frank after that, Frank Katie, and then that will likely be our last question.
Okay, so my question went back to how you assess the value, and you said that it would be based on the purchase price or construction, but in the case of a parent-child inheritance, how do you then determine what the fair market value of the property is upon the parent's death under the new Prop 19?
We look to the market value.
And that's just based on like sales in the area, the same way that, okay.
Similar homes, things like that, open transaction, things along those lines.
Great, thank you.
Okay. The next question is from Frank. Frank Katie.
Hi, can you hear me?
Yes, we can. Frank, we are not hearing you if you're speaking. I think I may have accidentally muted you by accident there. Please unmute.
Did that work?
Yep, that's much
How's
better
that?
now. Thank you.
Okay. Thank you guys. This has been very informative. I thought my questions was going to be a very simple one until I started hearing some of these answers, and now everything is just spinning in my head. I am from a county, northeastern California, where we have farms and timber production zones and ranches and all sorts of things like that. So the first question was, I take it that farms would include any other ag production facilities such as ranches and timber production properties and the like?
Richard, do you know the answer to that?
There's a definition right in section 2 right in the explicit language of Prop 19 that defines family farm as land that has or produces some agricultural commodity. And then agricultural commodity is defined by a provision in the government code. And I'm not aware whether or not that includes, I'm fairly certain it includes ranching. I don't know whether that includes timber.
I think that does, and I think extensive as opposed to intensive ag includes timber, as I recall the definitions. But yes, we can take care of that there. The other one is these production units, whatever they produce the farm products as defined, are not necessarily contiguous. You may have a processing for the farm. It may be processing in a facility in Modoc County. It may be grown in Lassen County. It may be further processed in Plumas County.
Yeah, go ahead.
Okay, so I take it this will apply throughout all the counties, which would require some coordination among the assessors, which might get back to the overriding, or not the overriding, but the one rule for everybody, such as the notarization rule we were talking about earlier.
Richard, do you want to?
Yeah, admittedly, I'm not an expert on farms.
Yeah.
But I suppose it goes back to what David had been saying about whether the farm will be appraised as an appraisal unit or some other way. So I could see, and again, this is an unknown thing. I could see where you know, a sort of an operating farm with parcels in different counties might be considered separate appraisal units, or perhaps maybe there's even it may even be appropriate, depending on the operation, to consider it one appraisal unit. I'm not sure. I think that's just something we'd have to, you know, look at when we get there.
Case by case, yes.
All right, I'm gonna
understand. Thank you.
So we're gonna close it out here. A couple just housekeeping things. We will be posting everything to everything we posted to the assessor's website, which we sccassessor.org. There'll be the entire presentation. There'll be the PowerPoints. All of the information will be posted to our website. Our website is dynamic, and we just launched with a whole bunch of more new information on that website. The Board of Equalization is an excellent resource for that. They're providing a lot of leadership on this issue and assistance to trying to interpret this. We apologize that we can't answer all the questions today. We just, many questions, as like we just heard from the previous person, do not come from our county. And we have limited resources and are really focused on trying to help residents in Santa Clara County. And other assessors are doing their best, I know, to try to be as responsive as possible. So with that, I'll see if the assessor Larry Stone would like to make any closing remarks, or Malia Cohen or Ellen.
Well, thank you very much. I really want to thank Malia and Richard and Nora and David, which I thought was a very engaging, even though we didn't have all the answers, because all the answers don't exist, as has been well stated today. So follow this very, very closely. Thank you, Ellen, and all of the people that worked to put this together. I think it was very good. And the only closing remark I'm going to make is stay tuned. Like everything else in property tax, particularly when the property tax comes off of a ballot measure, there's a lot of work that comes after the ballot measure passes, and this is one prime example of it. Thank you very much, everybody.
Member Cohen or Ellen, would you like to any additional closing remarks?
Thank you for giving me an opportunity. Just wanted to let people know that I represent 22 counties, so from Del Norte County down to Santa Barbara, and I'm available to help get questions answered as well. You can follow me on social media, Twitter, Facebook, Instagram, as well as the BOE website. Any way that you reach out to us, we will respond accordingly. If we don't know the answer ourselves, we will work to help find the answer. There's a lot of information out, a lot of questions out there and very little information. And I wanted just to note to, the California property owners, unfortunately, what happens when politics and policy interact, and so as a result, the policy could be very dynamic and changing as a result of the politics, as the politics for the state of California continue to change. So everything that we've discussed today is relevant and pertinent as of today, but who knows, there may be some sweeping changes, executive changes that may come about in the near future. So please stay in touch with us so that we are able to better keep you informed. Thank you.
And now finally, Ellen, if you want to say, and we greatly appreciate Ellen and the partnership with the California Lawyers Association, who helped to make this available today and make it free. So thank you very much, Ellen.
Yes, and we just want to thank the Assessor's Office for reaching out to CLA and the Trust and Estate section to get this message out to everyone. The Trust and Estate section has 7,000 lawyers statewide, and CLA is the second largest bar association in the nation. So please call on us again when you need to impart this type of information to our constituents, because that is what we are here for, and we thank you very much.
Thank you all. Have a nice afternoon.
Thank you.